May I please your lordship, I beg to mention for listing of a WPC for admission lordship,
Listing of
WPC
WPC.
for admission lordship, matter pertaining to compassionate appointment lordship,
All right. Next
for
week.
lordship.
Next week. Next week for admission.
Yes, lordship,
Next week.
plus lordship.
May I please, your lordship? I beg to mention item number 2. Senior Standing Counsel K. Kaur was supposed to appear, but he is not well today.
He's not well.
Yes.
Lordship, since it is a part-out matter, can it be before vacation? Or
Before vacation. Seventeenth. The request of MS Swenso appearing on behalf of Mr. K. Kaur, additional AG Assam. Matter stands adjourned. List again on 17/10. Mr. D. Das appears for the petition. Yes.
Bless you.
Lordship, in item number 6, Lordship, with permission to the other side, Lordship. I would like to take mention the passport method for the
Item 6 at the request of, he wants a passover. Any objection? Matter stands adjourned at the request of learned government advocate. Mr. R. Islam appears for the petition. Yes.
May I please, your lordship, I beg to mention item number 7. It may be password for the day, lordship.
Item 7, passover for the day at the request of Mr.
I am in, lordship.
I am in counsel for the petition. Yes.
Obliged.
May I please, your lordship? Lordship, before starting, while I was doing research, my lord, I got something interesting, my lord. This issue of 18 months and DLA, that has been, this was decided by the Honorable Uttarakhand High Court, my lord. In that case, it's a long judgment, my lord. Para 51 is relevant, the operative part.
Para 51.
51, my lord. Just, I got only 3 pages, my lord, because it's a long judgment. This will suffice, my lord. Para 51.
This will suffice for you. It doesn't suffice
My lord,
for us.
My
There is no
lord,
way to present
even
the
it will
judgment.
be suffice for courts also, my lord.
No. That is your presumption. You can't submit judgments with your paragraph that you want to read. If you want to rely on a judgment,
lord,
you submit the entire
My
judgment.
lord, just I'm relying on the issue only, my lord, here.
Mr. Counsel,
My lord, I understand, my lord. And that has been stated.
do not treat the court to be an extension of your chamber. Do
Sorry,
not.
my lord.
You are relying on something. You don't have the judgment. You give the citation. We'll take it out. We'll take it out. It's a long judgment. We can take it out.
My lord, I have given the judgment.
Yes.
My
What
lord,
do you want to say?
in that, my lord, the Honorable Uttarakhand High Court has said that the news that we allow all the read petitions and hold that 18-month DLA training diploma conducted through ODL mode in elementary education by the news is a valid diploma for applying against the regular post of assistant teachers in the state of Uttarakhand. It's a valid diploma for applying against the regular post, my lord. What Uttarakhand, Honorable Uttarakhand High Court has said at division bench. Thereafter, it was SLP was preferred before the Honorable Supreme Court, my lord. And in that, Honorable Supreme Court has stayed the said order, my lord.
So,
Now, the connecting issue here, whether the 18 months DLA course, the person having the 18 months DLA course is eligible for fresh recruitment or not, that is pending before the Honorable Supreme Court. Now, my humble submission before your lordship is that,
how do we know that this is the issue from para 51?
my lord,
How do we know that the issue pending before the Supreme Court
yes,
and this writ petition are one and the same? Yes, Mr. Chaudhary?
Lordship, I do not know whether he has the judgment of the Uttarakhand High Court.
He is given as para 51 of the judgment.
If I may take your Lordship to paragraph 22
Oh,
of the Uttarakhand High Court.
we have only para 51.
Oh, that is the issue. I'll just read out. I'll just read
No,
out.
we are asking you, what is it that he says the matter is
Yes,
pending before the apex?
that is true, Lordship. I'll just, for my lord, I'll just read out.
Hmm.
Paragraph 22 of the Uttarakhand High Court judgment. In pursuance of the aforesaid communication from the Government of India, the NCTE issued a communication on 6/1/21 addressed to the Chief Secretaries of all states, Union Territories, government, stating that the NCTE has already decided to accept the verdict of the Honorable Patna High Court in the case of Sanjay Kumar Yadav and others versus the state of Bihar and others, writ petition so and so. Therefore, you are requested to consider all those candidates who have completed DLED courses of NIOS, ODL mode, and may be given opportunity to apply for fresh recruitment at par with the other DLED candidates, subject to adherence of all other criteria and qualification requirements, such as passing of TET, etc., as per the NCT notification dated 23/8/2010, as amended from time to time, and any other as mandated by the state. The learned counsel for the petitioners submit that the government of Uttarakhand has also accepted the decision conveyed by the NCTE in its letter dated 6/1/21 by communication bearing so and so. The said communication was addressed to the Director Primary Education Uttarakhand. Learned counsel submits that on 29/12/2020, the government of Uttarakhand issued an advertisement inviting applications from eligible candidates to fill up the vacancies of assistant teacher grade 3 pay scale so and so in the government primary schools of district Pauri under the provisions prescribed in the government primary education teacher service rules 2012 in continuation of letter number so and so dated 9th November 2020 of the Director Primary Education Uttarakhand Dehradun. The communication inter alia states that every kind of selection process would be done as per the provisions prescribed in the Uttarakhand Primary Education Teachers Rules 2012. Now the next paragraph. The petitioners submitted their applications in response to the said advertisement. However, on 10/2/2021, the respondent government of Uttarakhand issued the impugned order cancelling the earlier order dated 15/1/21 on the same ground, namely that the in-service elementary teachers had undergone only 18 months and not 24 months DLED program. He contends the 24 months. On the other hand, the state has taken teachers who had completed 18 months. Of 18 months and not 24 months, DLED program conducted by the NIOS through ODL mode. Therefore, they were not treated to be eligible. The submission of the learned senior counsel for the petitioner is that the government of Uttarakhand is bound by the decision taken by the central government to authorize NIOS to conduct the DLED 18 months program through ODL mode, and is also bound by the recognition granted to the said course by the NCTE. He submits that education is covered by so-and-so. Lordship, these are the submission. Ultimately, the Honorable Court, by paragraph 51, which he was perhaps referring to, the writ petitions were allowed. We allow the writ petitions and hold that 18 months DLED training diploma conducted through ODL mode in the elementary education by the NIOS is a valid diploma. for applying against regular posts of assistant teachers in the state of Uttarakhand. The respondent shall therefore consider candidatures of petitioners for the said post on the basis of the applications made by them pursuant to the advertisement issued by the department. So, Lordship, Uttarakhand High Court had upheld that this 18 months would be at par. That is under challenge before the Honorable Supreme Court. Lordship.
So
And which has been stayed, my lord, by the Honorable Supreme Court.
it is submitted by the learned counsels of the bar.
My lord. Yes, my lord, one more submission, my lord. Here I am emphasizing only on one point, my lord. On the last occasion, also I have emphasized on that point itself, my lord, that the criteria, what they have mentioned in the advertisement, it is 2 years diploma in elementary
Is
education.
the issue in this writ petition and the one before the Supreme Court is one and the same?
My lord, my humble submission, it is the connecting issue, not all the issues, my lord.
One of the issues.
One of the issues, my lord, but
So if
not,
if that issue,
not the main issue, my lord, here.
if that issue is answered,
No, my lord, one more submission, my lord. If your lordships have a look at page 53, my lord, in my writ petition, where they have in essential qualification and experience, they have stated that the essential qualification is senior secondary with at least 50% marks and 2-year diploma in elementary education. My humble submission is that in the advertisement, the criteria is mentioned as 2 years diploma in elementary education. In that regard, my lord,
that is what I was
honorable-
asking you. You are giving us para 51. What were the facts involved in that case?
my lord, the issue is same. No doubt the issue is same, my
Then-
lord. But here the issue is something different. What is different? I'm placing your lordship.
No, no, no.
Because-
If the issue is same, you wait until
My
the
lord,
matter is over.
The respondent cannot alter the educational qualification. That is my submission, my lord.
That is subject to finding by the apex court that the very process of allowing 18 months DLED
My lord.
is contrary to law. If that is held, then the question,
The issue is something different here. Why
Why?
different? I'm
Why?
stating before your lordship.
you are limiting it only to the advertisement.
Only to the advertisement, my lord.
Exactly. But if the court upholds
Yes.
that there was no infirmity in allowing 18 months diploma DLED teachers to be included,
To be a regular appointee.
to be a
my lord.
regular appointee, then there is a question to decide whether that clause was required to be included, not
But the-
included. But assuming that was rejected, assuming it is it is interfered with, court holds that you cannot do it.
Yes.
Then your second issue need not be answered.
My lord.
Then
My lord may have disposed of it.
should we answer the second issue and then leave the first issue to be answered by the apex
My
court?
lord may dispose of only citing on the only issue that the criteria of advertisement cannot be altered at the time of selection, my lord.
No, no, no. It is submitted at the bar that a similar issue had arisen before Patna High Court, which was answered by the High Court in favor of the candidates having 18 months DLED. Patna had answered in favor.
Uttarakhand High Court, my lord.
No, initially Patna, I think.
Patna and
Patna
Tripura.
and Tripura High Court.
Patna. And then subsequently the matter came up before the Uttarakhand High Court. The Uttarakhand High Court by judgment and order delivered on 14/9/2022, following the judgment of the Patna High Court, allowed the claims of the candidates who were pursuing the 18 months DLED. Stop. This matter, as submitted at the bar, is presently before the apex court. The apex court by the order dated so and so 13/12/2022 has stayed the judgment of the Uttarakhand High Court. In that view of the matter, since a part of the matter is in session, since the apex court is in session of the part of a matter, part of the issues, the matter stands deferred for 8 weeks to be listed after orders of the apex court.
Party is at liberty to.
There's no
mention.
point deciding a part of the issue.
My lord, one more submission. Again, I have submitted. My lord may dispose it of only on that issue itself, my lord. That criteria of advertisement cannot be altered at the time of selection, my lord. I am,
That is your submission,
my lord.
or you're dictating the order for us.
No, my lord.
No, submission.
Yes,
We reject your submission, we'll dismiss it right away.
my lord.
We can
My-
do that. We are giving you an opportunity because the issue is whether the government has a right to treat 18 months and 2 years at par. That is the issue.
That is the.
That issue is pending before the apex court, as rightly pointed out by you. If that issue is answered in favor of the government, then the second issue arises whether they can change it in the meantime, or is it necessary to be disclosed in the advertisement. If that issue itself is rejected, then nothing is to be decided.
Not so, President.
Mr. R. Mazumdar for elementary,
Secondary.
secondary.
Now it is called the
Mr. R. K.
Departmental School Education.
Dev Chaudhary for Union of India. All right. Yes,
Highly obliged.
is released from part 13 of this order. Matter is released from part 3 of this order.
May I please your lordship? Your lordship, I have received an additional affidavit on 21st. I pray for some time in this matter to file my reply on this.
What reply you want to file?
Because
served on 20th, and this is their own document.
What
The whole
reply you
issue-
want?
your lordship, there is an allegation that we have misled the sub-staff category is not included with the sweepers category. So on this issue, I require to file an affidavit.
It is their own document. Lordship will have a look at the settlement and the qualification. Lordship may come to page number, my lord. 81. First 80. Lordship will see the qualification for staff staff. What is the eligibility, educational qualification and the job profile, 81.
1 minute. In the earlier matter, the SLP number be recorded. Order dated in SLP number 2. Sorry, yes.
Lordship may have a look at page 81.
No, but if he wants to reply,
My
you
lord,
can't
the
deny him his
copy was served on 20th of December. It is
28,
20.
20, your lord.
20.
And today
In
is
the evening,
20.
I have received your.
So, my lord, the case is on a very narrow campus.
Quite right, but if you have filed an additional affidavit, can he be denied his right of reply if he wants to reply for whatever it is worth? Because all these documents are the bank's documents, it doesn't
Yes.
require any reply, but if he says that he would like to have his instructions, then we can't, should we foreclose his
No, my
prayers?
lord, that is not
That's
my
the whole issue.
submission. But the thing is, my lord, the copy was served well in advance. So he could have obtained these instructions by this 7-8 days. That itself shows that is nothing but to.
How much time will you require?
Lordship, 2 weeks maybe.
2 weeks time. You file it within 1 week. We'll give you 10 days time. Mr. M. Sharma, learned counsel appearing for the bank, submits that an additional affidavit was filed by the petitioner and the same was served on him on 2009-2023. He submits that since there are averments made in the additional affidavit that the bank attempted to mislead the court, he submits that he'd like to complete his instructions and file a rejoinder if so advised. He prays for 2 weeks time. Yes, Mr. Chakraborty.
I pray for some less time, my lord. This.
We'll give him 10 days time.
Lordship will fix it on 12th.
Accordingly, matter stands adjourned. We deem it fit to grant him 10 days time to complete his instructions and file rejoinder affidavit if so required. Matter will be listed after 10 days.
12 of
12,
then my lord, from the
12.
next week after 12 the puja rush will start, so I want to take
No, I'm not getting a clearance from my court master in terms of the dockets.
12 till not difficult.
12, there are already 19 cases fixed for hearing. So yours will be
Come for
20.
the admission, my lord, it don't take much time, my lord.
Admission hearings. These are all admission hearing. So 17th is a good date, if you permit. We can fix it on 17th, which is a Tuesday. Let it be on 13th. Let us try
My lord.
on 13th.
Yes, sir.
17th would be meaningless. Let us
Yes.
try on 13th. Yes, list on 13th.
Friday the 30th.
Friday the 30th. That would be lucky for many.
Item number 4, my lord. It is, my lord, there is no affidavit has been filed, my lord, by the bank.
Yes, item 4,
4 and 5, your
4 and
lordship,
5. You
I
want to
have
file affidavit, you're relying on the same one.
Same affidavit will be.
Rely on the same, you serve
We
copies.
cannot change our, your lord.
Mr.
Served, your lord.
K.R. Patgiri, Learned Counsel appears for item number 4 and 5. Mr. S. K.R. Patgiri for 4, Mr. S. Islam for 5. And affidavits have been exchanged.
No, your lordship, we will serve, because I have found this.
Mr. Sharma, Learned Counsel for the bank, submits that the affidavit filed in this WPC 3394 will cover the issues involved in WPC 1735 and 2020 and 5479 of 2021. Stop. Mr. Sharma is therefore permitted to serve copies of the affidavit filed in WPC 3394 2018 to the learned counsels appearing for the writ petitioners in the other 2 items. List all the 3 items on 13th. Yes.
May it please your lordship. Lordship, if your lordship kindly peruse the last order of this honorable court, your lordship. That was passed on 7/8/2023.
Yes.
Lordship, we have yet to receive the updated instruction, your lordship. Already 12 crores has been released as per the VRS scheme to the petitioners. Now the remaining amount, we need to submit the utilization certificate in respect of the 12 crore amount.
How much time do you require?
Let it be after purification, your lordship.
Yes. Heard learned counsels for the parties. It is submitted by Mr. G. Borderloy, Learned Standing Counsel for the Cooperation Department. That in terms of the order dated 7/8/2023, passed by this court earlier, instructions have been sought for in respect of the amounts that required to be released by the government for disbursal of the entitlement of the petitioners, the instructions have not been received. He therefore prays for further time. He prays for 3 weeks further time. Prayer is not objected to
Since I considered that the whole process was not according to the laid down provisions of law,
What is the laid down provision?
provisions of law, since more than 15% was allotted as cutoff marks in Viva Voce. At the same time, the written marks were not aggregated along with the marks attained in group discussion as well as Viva Voce. And the whole procedure that was to be followed was not informed beforehand.
Show us on what proposition you are relying on.
There is a judgment in pertaining case number 1991 1 Supreme Court
You
662.
should give a list, Mr. Counsel. You should give a list to the court master.
I have a copy of the text.
No, copy is not necessary. Just give a list. All right, tell us the name. 1990.
1991 SSC 662.
90.
1991 1 SCC 662.
If you have an extra copy, give it. But normally you should give a list. Oh, yeah. Okay.
Another one is there.
Yes.
It is 150.
Paragraph.
Thirty-seven.
37.
Paragraph 37.
Hmm.
Page number. Mohinder Singh Garg, having secured 182.5 marks in the written examination and having 11th position in the merit of marks secured in the written paper, stood fairly good chance of being selected in case the selections were made on the basis of 15% marks kept in the Viva Voce. So far as the case of Balwinder Singh having secured 176.5 and Chiranji Lal Sharma having secured 170.5 marks are concerned, they also had a probable chance of being selected in case the percentage of marks in Viva Voce were reduced from 25% to 15%. In our case, the Viva Voce mark cutoff mark was 30%. Mr. Gujral made a submission before that no other read petition of the candidate in the general category pending before the High Court or before this court, though a long time has elapsed in the selection. It has been prayed that this petitioner shall be selected for appointment. The next page, point number, para number 38, we have taken into consideration the entire facts and circumstances of the cases. We have already taken the view that the selections already made cannot be set aside. Many candidates in the general category having secured lesser marks in the written examination in comparison to the above three petitioners, namely Mohinder Singh Garg, Chiranjit Lal, and Balvinder Singh, have been selected as taxation inspector. We do not consider it proper in the interest of justice to cancel the appointments and to give a direction to hold fresh election after reducing the percentage of marks in the viva voce test. No other candidate except the petitioners having secured more marks in the written examination than some of those who have been selected in the general. In my case, I have secured more than 72.5% in the written test.
So
In
what was the
Mohinder Singh,
Was there any cutoff mark?
in the written, the cutoff mark was 50% out of 100. Continuing with para number 38C. In Mohinder Singh Garg's case, this court on December 12, 1989 had given a direction that one post shall be kept vacant to be given to the petitioner in the event of his success. In Chiranjilal's case, this court on January 15, 1990 had given the direction that in the meantime, if further appointments are made by the respondents, one post should be left vacant to be made available to the petitioner in the event of his success. This is particularly the operative portion of
Read the para 35 or 34. 34, 35.
34 and 35A and 30. It's missing actually. I've taken
Huh?
34 and 35.
Yes.
We are also faced with the situation that the selections for the above posts have already been made and the selected candidates have already joined the post long back. They also are not implemented as parties before the High Court as well before us. In the above circumstances, it would be doing injustice to the candidates who have already been selected and have joined the post to quash their selection even if they hold 25% marks in the viva test, which were excessively high. 35, the question which now falls for consideration is as to what direction can be given in these cases. Petitioners Charanjit Singh and Davinder Prithpal Singh belong to the category of backward classes. Charanjit Singh had secured 143.5 and Davinder Prithpal Singh had secured 129 marks in the written paper. A perusal of the original mark sheet made available to us at the time of hearing shows that Charanjit Singh had applied for being considered for both posts of excise inspector as well as taxation inspector. He was, however, disqualified for the post of excise inspector due to non-fulfillment of physical standard as stated in the advertisement. Davinder Prithpal Singh had applied for the post of taxation inspector only, and both these petitioners could lay claim for the post of taxation inspector only. It may also be noted that only one post was reserved for the category of backward classes for the post of taxation. For the post of taxation inspector, 95 candidates belonging to the backward class had qualified in the written examination and as such called for interview. According to the respondents, one post reserved for the category of backward classes had gone to Bhupinder Pal Singh, who had secured 183 marks in the written papers and 50 marks in viva voce test. Thus, in all 233, it has been contended on behalf of the petitioner that Bhupinder Pal Singh, having secured 233 marks, was even entitled to have been selected in the general category itself, as the last candidate selected in the general category had secured much less marks than 233 secured by Bhupinder Pal Singh. We see no force in the above contention. The candidates have selected Bhupinder Pal Singh. The respondents have selected Bhupinder Pal Singh against the seat reserved for backward class. That apart, a large number of candidates belonging to backward class had secured very high marks in the written papers in comparison to the two petitioners, Charanjit Singh and Devinder Prithpal Singh, who had secured 143.5 and 129 marks in the written papers. The original mark sheet shows that at least 7 candidates of backward class have secured 170 and 176 marks in written papers, but were not selected in merit. Thus, even if we had quashed the entire selection and would have given a direction to hold the viva voce test afresh by reducing the percentage of marks, it would have been a futile exercise so far as these two petitioners are concerned, as there stood no chance of being selected even remotely. Even if for argument's sake, Bhupinder Pal Singh was given a post out of general category and then fill one post of taxation inspector out of the 95 candidates belonging to the category of backward class, it was well nigh impossible for the above mentioned two petitioners to lay any claim for the state one post reserved for backward class. According to Ashok Kumar Yadav, case candidates should be called only 3 times the number of seats available for appointment. If that criteria was applied, then the above mentioned two petitioners had even no chance of being called for the interview for one post of taxation inspector in the category of backward class. Thus, we find no force in the appeal filed by Davinder Pripal Singh and writ petition filed by Charanjit Singh.
Yes,
Gossip, para 33, point number A and B, that is also pertinent, like
para,
the
para,
para 33,
Uh.
A and B. A is dictum of all the authorities decided so far that the percentage of viva voce test in present
para 33.
para 33.
There's
Next
no-
page, A and B. Point number A and B.
Okay,
Dictum of all the authorities decided so far the percentage of viva voce test in present cases at 25% of the total marks is arbitrary and excessive. There should be no gainsaying that viva voce test cannot be totally dispensed with, but taking note of the situation and conditions prevailing in our country, it would not be reasonable to have the percentage of viva voce marks more than 15% of the total marks in the selection of candidates fresh from the college, school, or public employment by direct recruitment, where the rules provided for composite process of selection, namely written examination and interview.
yes. Then
In the next case, point number 38. Now coming back to the facts of the case in hand, so the rules framed under Article 309 of the Constitution governing the selection process mandated that there would be minimum qualifying marks each for the written test and oral interview. The cutoff mark for viva voce was not specified in the advertisement. In view of the omission, there were only two courses open: one to carry on with the selection process and to complete it without fixing any cutoff mark for the viva voce, and to prepare the select list on the basis of aggregate of marks obtained by the candidates in the written test and viva voce. That would have been clearly wrong and in violation of the statutory rule governing the selection. The other course was to fix the cutoff mark for viva voce and to notify the candidate call for interview about it. This is the course that the commission followed. It was in compliance with the rules and it did not cause any prejudice to any candidates either. We just see no irregularity in the selection. That means the selection.
what is the omission referred here? Para 38.
Hmm.
It says you are reading
They've
from
been clear
in view of the
violation of
omission.
the other course is to fix the cutoff mark for viva voce and to notify about the interview about. What does the commission follow? Commission.
Hmm?
Commission.
Yes, omission. What is the omission? What was omitted? Cut-off mark for Viva not specified.
Yes. In view of the omission, there were two courses open. Cutoff mark for the Viva was not specified in the advertisement. That is the
Yes. So essentially what you're saying is that in terms of this, the interview Viva marks were far higher. That led to arbitrary exercise of
there is enough scope for arbitrary. And we, from the mark, the sheet that they have.
when
attached,
was the interview held?
it was held in Guwahati.
Interview was held on 7/6/2010. Written was held on 6/6/10. 6/6/10 written was held
Interview 7/6,
2010.
written,
Group discussion
On the next day.
day.
written,
6/6/10.
group discussion. When was the group discussion held?
Written test on 7/6/2010, GD and Viva.
Yes. What is your name?
M. Dasgupta.
M.
M.
Okay. Yes, please.
The executive, the post of executive lady reserve or intended was notified. And accordingly, you can take notification of election post was based on written test about their medical. This most of it put any queries with content in her that was provided.
What was provided?
Uh,
16. 16 of your affidavit.
Yes.
Yes, 16 is provided conditions. What have you provided?
Put with the second last put any queries with consider
Sorry, last.
last time.
Any queries?
And accordingly, this activity was 6/9/2000.
When was the advertisement?
2000 last 2009 lordship. Last date of filling application was 10th.
That is in Annexure 1. Advertisement is dated
1/7/2009.
Where do you find it?
Lordship, in our PDP we have stated month of
Yes.
Accordingly, all the courses were completed in the year 2010, year of the result was there. And only in the year 2013.
Mm. Mm.
Filed this on 2013. Without the guideline, have conducted the entire that guideline is not taken. They can calculate the chance of knowledge of the chances for student. And after this stage of it now not done around.
Or if it is pertinent to mention here,
Yes.
It's not it's not clear. So the phase 18 law is the condition. Guideline and particularly it to erase the mark whereby 5 members have given the mark. Now is 19.
Mm.
The procedure would respect not the case if I have not stated anything anywhere law that we have given undue preference to any other candidate. We have given marks to other candidates.
His only case is that your fixing of excessive marks in the interview
In
is contrary to the judgment of the apex court.
the other case also not the effects to who tell that it will put 5% that in law, but ultimately selection was not there. And but in this case, there is a specific guideline and income.
Your guidelines can't be in conflict with the law. Can it be conflict? Can it be in conflict?
That is not challenged.
What is to be challenged?
That guidelines is not challenged.
It's not necessary. You hold selection process in a manner which is contrary to established law. Now you want to say that until and unless anybody challenges it, the process can go on. There is a subsequent judgment he has relied on Mohinder Singh Garg, Mohinder Singh Garg. There is no averment in your affidavit as to why you have given excessive marks. See, the problem is you have held, your selection is on 3 parts. One is written test, one is group discussion, one is viva. Now this person has qualified in all the 2. Now you have given sufficient marks in the interview. He's trying to make out a case that there is a sufficient room for arbitrariness.
Around in the base from 21 was given someone has given 20, someone has given 25, someone has given 20. Not that
less than 25, the cutoff mark. All had given less than 25, the cutoff mark.
And after 2 years, Lordship, of entire selection process was completed, he has
But your selection is made subject to outcome. You have not you have not prayed for vacating or modification. This, while issuing earlier orders, selection has been made subject to the outcome. Which order is it?
18 March 2013.
Election and appointment shall be subject to the outcome.
I was one and for five out of 5
Four has
Okay.
resigned. So what has happened to these posts now?
about the only one paper is there. Order number 4.
We want your response in respect of this judgment. Not fixing. This is 2013 matter. We'll take it up tomorrow. Tomorrow. We want your response here. What do you have to say? Prima facie, it appears that you have conducted the interview contrary to the law laid down by the apex court. This is not even a case that you conducted interview earlier, subsequently the judgment had come. Okay, tomorrow. Please tomorrow for further hearing. Heard so and so.
May I please?
Yes.
My lord, this is matter pertains to departmental proceeding, wherein the petitioner, who was a sub-register, has been imposed with a penalty of reduction in, my lord, pay scales, withholding of pay scale, and with cumulative effect. 3 increments have been withheld with cumulative effect. Now, my lord would see the charge, which my lord would find at page 19. First, he was placed under suspension on 15/3/2008, my lord. Then the charge is at page 19. Charge number 1, madam. That while you were serving as sub-register Guwahati, you have allegedly registered the following land sale deeds involving quantum of land measuring 7 biga 1 katha 10 lesa, along with Sarania, part 2 town so and so Uluvari. These are the deeds, madam. As per government approved zonal valuation table issued by memo number dated 5/12/2003, the village town Silpukuri falls under special category 2 zone with a value tag of rupees 5 lakhs per katha of land. The location of the scheduled land stands very much within 1 kilometer radius of Silpukuri tank, by which place the place is reportedly named after. The difference of rate of undervaluation stands at rupees 4 lakhs per katha, resulting in loss of revenue. My lord, till here, it's the facts. Now, my lord will go further. As per provision of 27A1 of the Indian Stamp Act Assam Amendment 2004, you should have referred the aforesaid land sale deeds to Deputy Commissioner after registering those land sale deeds for taking necessary follow-up action by Deputy Commissioner as per provision of 27A1 of the aforesaid Act. You have not followed the proviso of this aforesaid Stamp Act. Thus, you have not only violated the proviso of section 27A1 of the Stamp Act, but your such inaction has, this is important, has also left the Deputy Commissioner Kamrup Metro with no scope to initiate necessary steps for realization of the stamp duty as admissible by exercising his power provided under 27A2 of the Indian Stamp Assam Amendment Act 2004. Due to your inaction, scope of realization of further amount of stamp duty of so and registration fee of so was kept ineffective. Thus, you are charged with violation of Section 27A1 of the Indian Stamp Assam Amendment Act 2004. Now, my lord, the sum and substance of the allegation is that I had registered certain deeds. And therein, the values that were given, my lord, with regard to registration, there is no allegation against. But the value that was disclosed therein was said to be lower than the, my lord, ceiling prescribed by a notification dated 5/12/2003. And the allegation is, okay, you have registered, but why did you not send this to the deputy commissioner so that he could have recovered those amounts? And that's why, my lord, violation of 27A1 is called for. Now, my lord, first and foremost, the stand is, and it's not even proved, that this notification of 5/12/2003 never reached the sub-registrar's office. This was never gazetted. If it is gazetted, then it's a different question altogether. It was just an executive instruction. One, my lord. Two, my lord has seen that there is a further scope that the deputy commissioner was left with no other alternative because I did not forward to him. Now, my lord, 27A2, I'll show that the deputy commissioner has power within 2 years from the date of registration of a land deed to, my lord, Somoto, take it up, my lord. These registrations were made in the year 2007.
What is the job profile of a sub-registrar?
Sub-registrar, my lord, if we go before him with a document, both the parties are there. If it is properly valued with the value stamped and with the value mentioned therein, he is duty bound to register. He is not a revenue officer.
So in cases where recovery is required to be made, it can't be made by the sub-registrar.
It cannot be made by the
It has to be made by the deputy commissioner,
commissioner.
subject to such endorsement saying that this is undervalued.
If I, my lord, can determine that this registration which I did is undervalued, then I can send it to 27A1. I can send it to
ordinarily you are required to do.
which I'm required to do, provided
It was
that the
notified.
valuation is provided to me, madam.
It was notified. According
was-
to you,
I was
it's not
notified.
notified.
Or, my lord, there is another provision there. 27A2 says that the deputy commissioner, if he comes to learn about this, he can on his own. Sumoto. Now, that's the allegation, my lord, here, page 20, second line. But your such inaction has also left the deputy commissioner, Kamrup Metro, with no scope to initiate necessary steps for realization of stamp duty.
Now, after registration,
Lordship.
is there a process that it goes before the deputy commissioner?
No, it will go before the circle officer. The parties would take it to the circle officer for mutation. Mutation also happened here, but still not caught.
Now, the question is, how will the deputy commissioner know that these lands were
My lord, with
registered?
regard to the other deeds, I'm not even going. I'm only concerned with these deeds. I'll show how the deputy commissioner within 2 years came to know. My lord will see the date of the charge sheet. It is 10/9/2008. Show cause. This information reached the authorities much prior to that because I was placed under suspension on 15/3/2008.
Yes.
My lord, there is a letter of the deputy commissioner which forms a part of the list of documents. It is of 14/2/2008. My lord, page 21, list of documents, number 1, my lord. My lord has got it.
Yes. No,
Letter number
20
so-and-so dated 14/2/2008.
21 of
Page 21 of the writ petition.
writ
Down
petition
below, my lord.
is a statement of allegation.
Statement of allegation down below, list of documents.
Yes.
Letter number so-and-so dated 14/2/2008 of Deputy Commissioner so-and-so. My lord, even need not go into it. My lord will say the date of my suspension 15/3/2008. Now, these deeds were registered in the month of March 2007. You had all information about that, but you still did not act.
So that's what I'm asking you.
Lordship.
How is the deputy commissioner supposed to be apprised that these registrations were below the
There are
ceiling?
two ways, my lord. If my lord can have the Indian Stamp Act
It's an Indian stamp act.
I'll give this. My lord will have. I have a copy.
Yes,
My lord will have section 27 there.
27.
20, that's the Assam amendment, my lord.
Uh,
My lord has got it.
yeah,
My lord, 27A1. If the registering officer appointed under Registration Act so and so, while registering any instrument of conveyance, exchange, or gift, has reason to believe that the market value of the property as fixed by the government collector of the district, which is subject matter of the conveyance, exchange, or gift, has not been truly set forth in the instrument, he may, after registering such instrument, refer the same to the collector for determination of the market value of for such proper and the property duly payable thereon. Now, my lord would have 3.
Mm.
The collector may, on his own motion or otherwise, within 2 years from the date of registration of any instrument or conveyance, exchange, or gift not already referred to him under subsection 1, call for and examine the instrument for purpose of satisfying himself as to the correctness of the market value of the property as set forth in the instrument, which is subject matter of conveyance, exchange, or gift, and the duty payable thereon. And if after such examination he has reason to believe that the market value of such property has not been truly set forth in the instrument, he may determine the market value of such property and the duty as aforesaid, and thereupon the difference, if any, in the amount of duty shall be payable by the person liable to pay the duty, provided that nothing shall so and so before the Amendment Act 2004. Now, he is the district registrar, madam. So everything is done under it's his office, madam. So he is in no, but I can forward it to him. But 3 says, from any source, if he gets an information, he can so moto do it. Now, my lord would see in this case, the land deeds, my lord may just make a note, the land were registered in the month of March 2007. 2 years time, 2009. But they knew about it, at least I forget everything, my lord. They knew it as of 10/9/2008. No steps taken.
what did you, what was your stand before the inquiry?
Inquiry, my stand was, my lord, I'll have the inquiry report straight away before my lord.
No, in your written statement?
Written statement, my lord, this was that I never had an occasion to receive that, my lord, 5/9/2003 order. Para 4, page 24, my lord.
He says due to oversight.
No, that my lord is just his, but my lord, the main one is at para 4, my lord. Para 4.
Para 4.
Para 4, my lord.
Yes.
Page 24, para 4. The government circular number so and so referred to in the show cause notice was a mere inter-office communication addressed to the Deputy Commissioner Kamrup and Settlement Officer Kamrup, resettlement operation with copy to Commissioner Division so and so, all officers, Revenue Department, PSC so and so. As the answering deponent delinquent did not have knowledge of the same, hence on principle alone, no liability should be attributed to the delinquent, answering delinquent who was unaware of the said government direction. Had there been a formal gazette notification in lieu of the said office order of the registering officers as well as the revenue officers, allowing mutation on basis of such deed, would have been able to refuse registration of the documents as well as mutations granted thereon.
Now, where is that offending?
Lordship, my lord would have it at page 28, 27, my lord, sorry. I think it's the first page, maybe 28, my lord.
28.
First page, somehow in my paper, it's the 28, my lord. It's a letter, that communication dated 5/12/2003, my lord has got it.
Yes.
In inviting a reference to a subject quoted above, this is to the Deputy Commissioner Kamrup Metro. so and so have not been getting any additional amount as revenue, either from the premium for settlement of land or as stamp duty or registration fee during transfer of land, mainly due to non-enhancement of value of land by the government. Due to this, government has already lost a considerable amount of revenue while the government is reeling under financial crisis. In view of this situation, government have carefully examined the matter relating to enhancement value of the town land under Guwahati, Greater Guwahati, and decided to enhance the value as shown below. This value will come into effect immediately and will remain in force until further order and shall have to be quoted as value in consideration during registration of deeds and value of land for fixation of premium on settlement of loan. Then page 27, my lord, is the revised value.
What is this? All officers, these copies are marked to all
Marked
officers?
to officers, revenue department. I don't come under that, my lord.
You come under?
I'm a registering authority. I'm not a revenue officer, my lord.
No,
And
no.
this revenue department is Deputy Secretary H. That is, my lord, in the dispute. And that has not even, my lord, even been gone into. And my lord would have page 36. My lord asked me
36.
what my role exactly is. My lord, 36.
Yes.
This is a letter from the district register with reference to the letter cited. This is given to the resettlement officer. I have the honor to inform you that registering officers are not empowered to inquire whether the immovable property.
You're referring to which
Page
page?
36.
36.
30, sorry, man, sorry, 30.
30.
30.
Yes.
With reference to your letter cited above, I have the honor to inform you that registering officers are not empowered to inquire whether the immovable property mentioned in the sale transfer deed are properly valued or not. There is no such provision in the Indian Registration Act under which the registering officers are appointed. Then, my lord, the other two are with regard to Paniketi registration and all. So, my lord, this is the position actually. Now, my lord would have the inquiry report. There were two witnesses, my lord, in the show cause that was given to me. One Povitro Das, junior assistant, and one Bipin Goswami, extra writer. These were the two witnesses. Now, the report is at page 32, my lord. No evidence at all, my lord. And that's what I'll try to. First, my lord, the charge itself is not sustainable. My lord would have the inquiry report. I'll have the second paragraph, my lord. The allegation in brief against the charge officer was, while he was serving as sub-register Guwahati during 2007, he allegedly registered 15 numbers of sale deed involving an area measuring more or less 7 bigha, 1 katha 10 lesines or soina under Ulubari at lesser value than fixed by government for sale purchase situated in White so-and-so dated 5/12/2003 and thereby incurred a loss to government revenue. He also failed to refer the matter to the district register as provided under section 27A1 of the Indian stamp so-and-so, and thereby left no scope for the district register to take necessary action for realization of stamp duty and registration fee. Now, my lord, statement of charged officer so-and-so and witness so-and-so were recorded on 21/2010 and 25/2/2010 respectively. The other witness, Sri Bipin Goswami, although was present on 21/2010, refused to make any statement. So one witness, no statement. Now, my lord, Sri Goswami agreed to have registered these alleged sale deeds during March 2007. My lord will just make a note of that. At value shown by the deed, in the deed by the sellers and purchasers, but stated that he was not aware of the government circular number so-and-so, fixing land value for the purpose of sale purchase in Guwahati, and therefore registered the deeds only after ascertaining the value of stamp effects on the deeds as per value of transaction. In short, he agreed to have registered the deeds at a lower valuation due to his ignorance about the government circular fixing value of such land. This is my stand, madam. Now, the other witness, Sri Povitro Kumar Das, LDA, who is listed as one of the witnesses by the department in his statement, denied having any knowledge about the subject as his work allocation involves mainly furnishing of papers relating to court cases and submission of lists of registered deed to IGR Assam after the entry in the relevant volumes. Therefore, his statement is not very essential in this case. If I may just pause for a moment here, but the documents that were there, which ought to have been proved, will be done through a witness, my lord. Both the witnesses not examined, literally. So, my lord, the charge that was there could never have been held to be proved. There was nothing. What cross-examination? They deposed behind my back, fine, my lord. But even if they had deposed this thing before me, no scope of cross-examination because no material was used. Now, my lord would see the conclusion. From the above, it is clear that the charge officer executed 15 numbers of land sale deeds shown in the so-and-so while he was serving as so-and-so. It is also seen that the deeds were registered by him at a lower value than the land valuation fixed by the government in registration department, so-and-so. As a responsible officer, he is expected to have knowledge of relevant acts, rules, and other government instructions issued through circulars by the concerned department for smooth functioning of duties and responsibilities entrusted on responsible officers. His failure to follow so-and-so cost heavy on government exchequer as he failed to refer the matter to so-and-so. Under so-and-so. Considering the above, charges leveled against so-and-so.
Mr. Nair,
Lordship.
the issue is not whether this particular circular was there or not. It was there, you admit, they also admit.
But it never came to me.
So this is what perhaps,
They had to prove.
no, I think you have to say the manner of the documents being circulated is prescribed under so-and-so rules or so-and-so practice or whatever.
No, my lord.
In that,
There are two charges against me, basically.
Ah,
There are two charges. My lord, the charge, my lord, I'll just, for my benefit, my lord, if lordship
Yes.
can just come back to the charge. The allegation against me, page 20, those are allegations, my lord.
yes,
Page 20, my lord, would come,
charges.
charges.
Hmm.
Thus, you are charged of violation of section 27A1 of the Indian Stamp Assam Amendment Act 2004. Go, my lord. Why? Because the value which was there in the sale deeds were lower than 5/3/2003 circular. My stand is, this circular never reached me.
Exactly.
My lord, that has to be
But
proved.
no, you have to say,
Lordship,
subject to correction,
lordship.
what is the procedure prescribed for circulars being distributed in
My lord, these
offices?
circulars are these are, when a land value is fixed, my lord, it is normally gazetted. I have said that in my written statement, my lord.
So you have to bring evidence that these are the circular. Let us say in revenue department, there will be numerous circulars.
My lord, as in a
raising
criminal case,
values.
as in a criminal case, it is for the department to establish their own allegation, my lord.
No. If it was a case that you disputed the existence of this
I
particular
never
document.
disputed the existence.
Exactly.
What I'm saying is,
Exactly.
it never came to me.
That's right.
And they could not prove the contrary, my lord.
No.
My lord will have. because,
They,
my lord, if
they-
this is the evidence
they have proceeded on a presumption that since this is a circular, you being a government officer, you're expected to know.
how can I
Now,
know
it
a
is- it
circular,
is-
my
it
lord, which
is-
was never, okay, my lord. Okay. Let us hold that, my lord. That is that I knew about this circular, still I did not.
No. We are not saying that.
No, my lord. I'm just trying to, my
We
lord.
are not saying that.
Lordship.
What we want to know is there any material to show that ordinarily, let us say you say it requires to be gazetted,
Lordship.
then you'll have to perhaps bring in some amount of evidence to suggest that these kind of circulars
No.
are required to be
My lord,
gazette notified.
in my written statement, I had categorically stated that. my lord.
You first stated it was oversight.
Oversight. No, that, my lord, is with regard to
Then you said it
27A1.
was not formal gazette notified.
My lord, he said this was never referred to me. This had never come to my office. And
All right, just a passing thought.
lordship,
We are not-
I understand. I'll have to satisfy your lordship on that also.
We are not.
And my lord, even that page 30 letter,
Because if this proposition is to be accepted,
lordship,
then there are hundreds of circulars, notifications. Anybody can stand up and say,
My lord,
never served.
that is why I'm saying. The only thing they had to do is,
Hmm.
my lord, that circular in the inquiry was never proved, my lord, because it was never produced in the inquiry. My lord will accept one fact, my lord.
No,
In
no.
an inquiry,
No, that You are questioning the very existence of a circular that was never issued.
No, no, my lord, I'm not, my lord will bear with me. What I'm trying to say, there is a circular 53/2000. Your allegation is 53/2003 denoted certain rates. You registered it in a rate below that. Fine. But okay, you registered below that rate. Why didn't you forward it to the deputy commissioner afterwards? So that is the allegation against me. 27A1 violation. Why I did not send it to the deputy commissioner for my lord
Recovery.
his recovery, because I can't. Now my case was, if I had known about the existence of 5/3/2003, I would have sent it. I did not know. So my lord, my registration of that document is not being questioned. Question the charge is, my lord, they can't go beyond the charge. The charge is
So therefore,
lordship.
therefore, you have to say that this is not hit or this is not covered by ordinarily accepted principles that ignorance is not a defense of law. This is not a
cannot be.
law in a sense that
That is exactly what I said, my lord. Yeah, I'm sorry I could not communicate to my lord.
No, you
That's
said
exactly
it
what I
was not-
said.
it was
If
not
my lord
gazetted.
can come to
You
page
said it was
24.
not gazetted. We have
Page
read it.
yes, my lord, because if it is not gazetted,
Therefore, you have to satisfy, or at least prima facie, that these kind of documents are need to be gazette notified.
my lord, normally anything with regard to such
Unless you say that this notification being issued by so-and-so secretary was never sent out of the file in the first place.
no, it might have sent because it was never marked to us, my lord.
May not have been.
It never was marked to us. My lord will come back to page 27, my lord.
Not being marked to you does not mean.
No, we are, because my lord, this registration is done in the sub-registry, man, not any other place. This whole area it's only covered by my lord, the Panbazar, my lord, earlier Panbazar DC office, my lord. My lord would see.
Anyway, we take note of your
and my lord will come to the inquiry report.
Hmm.
The inquiry report, there is no witness, my lord.
To what effect?
Effect would be those documents were never before the inquiry officer cannot on his own take up and proceed, my lord. He will have to be.
That's what I'm saying.
Lordship.
That there was no the question of whether this document existed or not.
No,
Not an issue at all.
no, my lord. Why I'm saying so? Mere listing of a document will not prove it, my lord. My lord will have page 21, the documents that were there.
No, that means you're questioning the existence of the.
No, I'm not questioning. I'm questioning the manner in which the allegations were sought to be proved. There is a difference, my lord, in both. My lord will have
Then
page
you'll have
21.
then you'll have to support your case by saying that this is the practice or these are the norms in which the documents are, if required, to
My
be
lord,
brought to your notice.
that's one aspect, my lord. That is one aspect. What I am on is, in a departmental proceeding, if lordship can just have page 21.
21, yes.
21. List of documents.
Yes.
So that allegation that is against me, my lord, page 21. My lord has got it.
So that's it.
No, my lord.
That's a technical issue.
No,
You're right.
I'm on a different issue altogether.
That this document was never produced, no witness.
No. I'm not on that. My lord, this is the allegation. These are the documents by which this allegation will be proved. And these are the witnesses who will produce these documents. Rup Singh Negi's case is there, my lord.
What is this inquiry report?
That's what, my lord. We don't know because that person never was a witness, my lord.
That copy was not served.
No.
The list of documents, you said it was there.
The list of documents are there. The documents were never there. These, my lord, were never produced through an inquiry, through an witness before the inquiry.
This is a part of the show cause, isn't it?
Yes, my lord. These documents were taken by the inquiry officer on his own, without being proved in the inquiry.
Was it served to you in the first place?
No, my lord. It was produced in the inquiry only.
So you mean to say these list of documents listed were never served to you?
Never served to me.
Have you made a statement in the writ petition?
Lordship.
Even in your reply, did you say anything about it?
Lordship, in the, my lord would find it in my reply to the inquiry officer's report, madam. I've said it somewhere. Para 16, madam, no? Para 16, yes,
Para 16.
Lordship.
This is page number
My lord, 12.
12,
Under reply to Lordship.
para 16.
Lordship. The petition states that even the mandated safeguards available to a delinquent employee facing charges in a department proceeding were
No,
totally flouted
This is the subsequent in the inquiry.
in the inquiry. Well, I'm only on the inquiry part.
No, while you said this list of documents.
No,
which
no,
you gave-
that's what I'm saying, Malak. Flouted inasmuch as copies of the listed documents and relied against him in the inquiry were not provided to him. The denial of opportunity of cross-examination of the prosecutor and affording opportunity to place defense documents and witnesses, all these illegalities go to